everybody. Welcome to a special Tuesday night edition. Whoops, better take these out. Well, there's big news. So we're going live tonight, as I promised you we would be doing more and more of as the trial got closer, because there is huge news tonight. If you felt the earth tremble along about 10 o'clock this morning, you are not the only one, because the judge has dismissed the death penalty as it applies to Lori Vallow Daybell, only Lori. He made that very clear, that he made this only apply to Lori's case, and that it applies to Lori's case because of my husband sticking his tongue out at me as he went by the door. It applies only to Lori's case because Chad would have additional time to cure some of the discovery issues. So very interesting. And we have so much to talk about. How does this impact the case? What happens next? I will say, maybe it's just my defense attorney spidey senses. I don't know for sure. But what I will say is I could feel the prosecution's, the level of stunned the prosecution was. I could just feel it in the recording. Rob Wood closed out the hearing by asking the court for an expedited transcript of today's hearing. And that tells me that they're going to at least attempt some sort of what's called an interlocutory appeal, meaning an appeal that happens before the final judgment is entered. So it is an appeal that goes on during the pendency of the case. I don't know that that's going to go very far, because prosecutors have very limited rights of appeal. So it's going to be very interesting to see what happens. Judge Boyce said this trial is going ahead on April 3rd. So we will see what happens. I have my doubts whether Rob Wood would be in a position to get an interlocutory appeal before April 3rd, but I'm certain that they are going to appeal it. And this just adds yet another layer of appellate practice and ongoing appeals that are going to go on in this case for years. I still half expect for this case to come back for a retrial on Lori's case, because of the speedy trial issue, because of the lack of discovery. Now, Judge Boyce did not go as far as to say the prosecution was not acting in good faith, which is a legal standard. But he did go as far as to say, there was a discovery deadline. Not only did you provide stuff after the deadline, 24 hours after, but then the following week you dumped another 3,000 jail calls on the defense. And I think that was kind of what tipped him over. And the very idea that it wasn't physically possible for the defense to somehow listen to and then be able to investigate anything needing investigation by the time the trial started. So the judge found that simply trying to keep evidence out wasn't effective and wasn't fair for either party. And so he ruled that the notice of intent to seek the death penalty, as it applies only to Lori, it is dismissed, and she will not be seeking the death penalty. She will not be facing the death penalty. Now, what does that mean for the trial? Well, I think it means we're going to see a much shorter trial. Now, perhaps not instead of 8 to 10 weeks, perhaps 6 weeks. But still, I think we're going to see a less intense and a shorter trial. I think we're going to see a much shorter jury selection process. When you do not have to death qualify a jury, it takes much less time. So I think those are the things that are going to happen. Of course, we're not going to have a death penalty phase, so that's off the table. We're not going to have a mitigation phase. So it's going to be really interesting to see how this impacts the prosecution's case. Yeah, I think that the judge telegraphed that he was considering it at the last hearing. So we went back and listened to the May 15th hearing. And in fact, the judge did bring up to the prosecution that there was legal precedent for the court to dismiss the death penalty. Now, interestingly, there is not precedent in Idaho. I think a lot of people don't really understand how much trial judges rely on precedent. It is very difficult to get a trial level judge to make new law by finding something that's not supported by precedent. It's rare. So I was shocked for this reason. There is no precedent in Idaho. Now, there is precedent in other states, and there is precedent in the federal government. In the grand scheme of how persuasive an argument is and how controlling it is, first are statutes. Second are state cases that interpret that statute. So the second most persuasive kind of rule would be case law from the state of Idaho. In this case, there is no case law in the state of Idaho on this issue. So the judge was forced to look to other places. The least persuasive is another state. So the neck in between the state of Idaho and another state is the federal government. So the federal government, what they're looking at is appeals where the federal government was prosecuting the case. That is different from the federal government taking up and then interpreting a state finding. So it's a little bit different, but looking at cases where the federal government prosecuted those death penalty cases. It was really interesting from a law geek standpoint. The arguments were interesting. And I felt to some extent that the judge felt that he really had his feet to the fire. He didn't really have a choice. Nonetheless, I felt that level of stunned shock from the prosecution. And I thought it was really interesting. This is a county where the old boys still rule, and where folks who are involved in the church, in the culture of Rexburg and of Fremont and Madison counties, really have held sway. And so it was pretty interesting to see. I think I said a couple of hearings ago, it's interesting. It feels like Judge Boyce is finally finding his feet, both as a district court judge and as a judge in a death penalty case. So I thought that was super interesting, that he appeared to finally stand up and say, no more of this. There's been all this monkey business. And he pointed out in today's hearing that he has been hearing complaints about discovery since the very beginning of this case. And it was interesting that when they got to the point where they were talking about the jail calls, he pointed out that there was a motion to compel to get those jail calls in 2021, 2 years ago. And the defense said, we'll give them to you as soon as we get them and they're in some sort of downloadable form. They promised the court that they would produce those by July of 2021. That's 2 years ago. And they were never produced. And the defense was entitled to rely on the fact that if they didn't produce them, there weren't any. And in fact, there were 3,000 of them. So I think the judge, that along with the fact that they weren't turned over until days after the discovery deadline, I think the judge was just out of patience. So it was very interesting to see. I understand that there are many people who are upset about this outcome. I'm not making a judgment on whether or not Lori Vallow should get the death penalty. I'm talking about the legal issues. And from that standpoint, I thought it was very encouraging that Judge Boyce has finally shown a little backbone. And he's finally holding the prosecution to account for some of the things that they've done. So I think it bodes well for a better, more fair trial. But I do know that a lot of people are unhappy that Lori Vallow is not going to face the death penalty. At this point, Chad Daybell still is. So I understand that there are many reasons why the death penalty is impractical. The judge pointed out that it is a solution that is irrevocable. Once you have killed someone, if you later find out they're innocent, it's too late. And we have copious examples as technology has gotten better of cases where defendants have been exonerated after years in prison for crimes they didn't commit. So add to that the tremendous cost of a death penalty case. The prosecution released information to Nate Eaton at East Idaho News indicating that this case has already cost Idaho taxpayers, specifically Fremont County, although I'm certain they're getting help from the state government, $3.6 million. That is a drop in the bucket compared to what will happen if there is a death penalty conviction. There is a man on death row in Idaho. His name is Gerald Pizzuto. I've talked about him in my newsletters before. And he has been on death row for 35 years. In that 35 years, he's exhausted all his state appeals, exhausted all his federal appeals, all costing the state money for his court-appointed attorneys who are being paid by the state. And now the state, he's finally exhausted all of both his state and federal appeals. The court issued a death warrant and set a date for his execution. And the court had to vacate that sentence because Idaho can't get the drugs, the chemicals that are used in a lethal injection execution. That is because the people who manufacture those drugs have decided as a matter of conscience that they will not sell to states that are using those drugs for the purpose of execution. Now, some states have got around it by going to compounding pharmacies who then put together this cocktail. But a lot of the states have not had good luck with those, and they have resulted in some pretty gruesome and inhumane lethal injection executions. And it's for that reason that there are several states, including my home state of Oregon, who put a moratorium on executions. Just recently, the outgoing governor of the state of Oregon commuted all of the death penalty sentences to life without the possibility of parole. That was sort of her end of her 8-year term, her 2 terms, parting swan song. But it goes to show that the death penalty is less I think people are less convinced that the death penalty is effective or that it is in any way better than life in prison without parole. Um, I mean, I can see it both ways. I see both sides of the argument. But from a strictly practical standpoint, if you know that this person that is um, going to be ordered, found guilty and going to be sentenced to death, if you know this person is going to spend 35 years in prison fighting that conviction, and it's going to cost the taxpayers millions of dollars for them to mount those appeals, it does make you wonder whether it's the most cost-effective way to do business. Throughout the country, the average cost of a prisoner is somewhere around $30,000 a year. It costs triple that to house a death penalty prisoner because of the cost of all of their appeals and all of the other stuff that goes into it, whether it's new mental health evaluations, whether it's many lawyers on a team getting trial transcripts, and I mean the cost is enormous over time. So it does make you sort of wonder whether the death penalty is the most practical way of imposing a sentence. In this case, Lori's not going to face the death penalty, and that changes things. It changes a lot of things. It could even change their plea negotiations. My understanding of what was going on is that Lori's attorneys are still really firmly convinced that she has serious mental health issues, and they have been lobbying for a sentence that would allow her to serve her sentence in a mental institution. She would be subject to all of the same security provisions that she is under in prison, but she would be there for her lifetime. And I don't think the prosecutor has been at all amenable to that, and that's been the sticking point for them. Now, I don't know whether taking the death penalty off the table helps or hinders those negotiations, but I think that it changes the calculus altogether. So I think it's going to be easier to pick a jury. I think the trial is going to go faster. And I think I think we're looking at maybe a more certain outcome. If she is convicted, she will be convicted of life without the possibility of parole. So the fact that the death penalty was taken off the table does not necessarily mean that she would be eligible for parole. So it's an interesting question, though, because in Idaho, the only way you get to life without the possibility of parole is if the prosecution seeks the death penalty. So that is going to have to be an interpretation. It's going to have to be up to the judge and the appeals courts as to whether or not, if the notice of death penalty is dismissed, she becomes eligible for parole after 25 years, I think it is. So I get Arizona and Idaho confused as to when they're eligible for parole. So I want to thank everybody who's joining us tonight. We have almost 400 people in the chat. I've seen a couple of super chats go by. I'm going to get ready to open up for questions, but I want to remind you of a few things before we get started. Thank you all for the super chats. They mean the world to me, and I know they mean the world to our mods, because all of your donations that come in through super chats or through our PayPal channel go directly to our mods. So I'm thrilled to be able to share that with them, because I couldn't do it without them. I don't have the time or the energy. And y'all have seen the days when I didn't have a moderator and I was squinting reading the questions, and you don't want that. So thanks very much to our mods. I wanted to point out that we're getting down to the last squares in our True Crime Quilt Guild. You can see the squares are up there on the wall. There's a couple of new ones up there. I have been trying my best to get the final instruction video out for the blocks. And of course, things have just keep cropping up. So I'm going to try and get that out tomorrow so that we can all finish our blocks. And then I will get one more episode out on how to connect them all up and put the quilt top together. But we should have that done before the trial starts. That was my goal, was for this to be a project we could all do together while we were waiting for the trial. So that's almost done. I do want to let everybody know there will be no TGIF. I'll post that in all the appropriate places, but there will be no TGIF this week. I'm headed down to LA to help my daughter with all of the last wedding preparation for her wedding in May. And so I won't be here on Friday, but I am appearing on Monday again with Gigi at Surviving the Survivor. So I'll post those links so you can catch me on Monday. So we are going to have True Crime Wednesday tomorrow night. So you get 2 doses of me this week, one special on Tuesday. Wednesday tomorrow night we'll do True Crime Wednesday. Friday, no TGIF. Monday, I'm going to be on with Joel and Surviving the Survivor with Gigi. And also on will be the woman who was the producer of the Netflix series Sins of Our Mothers. So we're going to have a great discussion there. I'm looking forward to that. And then we'll be normal Wednesday, Friday for the following week. And then the trial begins. And we're going to have a big schedule change once the trial begins. So I just want to thank everybody again for being with us and tuning in. It's a big deal today. In fact, I usually limit my glass of wine to Friday nights, but it's a big deal today. So I'm having a glass of wine. Hope you all are well and joining us too. So let's see if we can get to some of your questions. Trisha the Trucker. You know, you should always preface your question by telling us where you are, because I'm dying to know where you are tonight, and wishing you being safe out on the road. Question: had Pryor not pushed so hard to separate the trials and Chad and Lori's trial were still combined and going on April 3rd, would they both have had death taken off? That's a great question, and I think it's a real possibility. The reason why the judge in the hearing today said, I know that the state asked me if I would continue the trial, and there's just no way I can, because she has been adamant about not waiving her right to a speedy trial. So I think there was a very good chance that the death penalty could have been taken off for both if Chad had gone forward in April. But he's going to get extra time. And we don't really know how this will impact his trial. It may be that the defense is able to go back to the prosecution and say, okay, you took the death off the table for her. Let's talk about taking it off for him too. You know, I mean, just as a practical matter at this point. And the other thing is, now that these cases are severed, we don't know what's going to come out at trial because we have not seen all that evidence. But, you know, sometimes trials go directions that you don't expect, even when you're the prepared defense lawyer or the prepared prosecution. As I say, I don't think the prosecution anticipated this ruling at all. I think they were stunned. And so a lot could change between now and the time that Chad's case goes to trial. But I wouldn't be surprised for there to be some discussion about taking the death penalty off for him too. Wherever you are tonight, Trisha, be safe. Hey, Laura Ferris. Should they drop the charges and file again? I worry it will come back on appeal, and that would be so horrible for the families. To be honest, appeal is inevitable in this case. And I think that there have been enough questionable steps in this case that I'm comfortable predicting that Lori will get a new trial. I think that there have been enough slip ups and mistakes that that's probably going to happen. That said, they couldn't go back and retry her and ask for the death penalty. The death penalty is, this decision's permanent. So, even if Lori's case comes back on appeal and she gets a new trial, it won't be for the death penalty. I feel bad for the families as well. I haven't reached out to Kay and Larry yet. I will, but they've got plenty on their plates right now. Lots of other people who want to get in touch with them. So, but that was, of course, my first thought as well. Oh, poor Kay and Larry. That's going to be devastating for them. So I don't think they should drop the charges and file again. That can be a little dangerous. And even if they were to drop these charges and refile them, I think they would still be in a little bit of the same muck. So I don't know that would be particularly effective. I think they're sort of committed at this point. They need to just power through, and they should have hired a discovery clerk. It would have been pretty simple. So, hi, Nikki Fife. Could the judge impose specific years over the life sentence so that she will ultimately serve until she dies? Well, sure. And here's the way you do it. Here's the way he would do it, and it's very possible. He would make the sentences. Now there is a legal concept called merger. And what it says is that sentences that are essentially for the same criminal act have to merge together into a single sentence. So, for example, if you go rob a bank and in the middle of the bank, it's an armed robbery, and in the middle of the bank, you shoot someone and you get tried for murder, and it's capital murder because it's a felony. It was in the commission of a felony. Then the most serious sentence controls. Let's say they don't ask for the death penalty. They just ask for life. The most serious of those sentences prevails. But if they are different criminal acts, and in this case, we have 3 distinct criminal acts. We have Tylee's death, we have JJ's death, and we have Tammy's death. The judge could stack those sentences consecutively, which means that she would have to serve the first sentence to completion before she could serve the next, which means that if she, let's just say, got life in prison with the possibility of parole, and let's just for grins say that she has to serve 20 years before she's eligible. Well, when she became eligible for parole, the next sentence would kick in. So it would not be 20 years. It would be 3 times 20, 20, 20, 20 stacked up. So there are ways that the court can structure a sentence so it's clear that she's never going to get out of prison. And I expect that will be what will happen. I do not expect that there's going to be a sentence that would include her being eligible for parole in any meaningful way. So, but the judge can do that by imposing a sentence that she has to serve consecutively because they're separate criminal acts. Good question. Thanks, Nikki. Jennifer M. Thank you for your donation to our mods, Jennifer. It's much appreciated. What will happen when they finally release Tylee and JJ? Who will be there for Tylee? It's my understanding, and this is something that could change and could be different later than it is now. But it was my understanding that the families had agreed that Tylee would be released to Larry and Kay so that she and JJ could be together. So That's my understanding. Um, I mean, families make different decisions, and sometimes these kinds of cases cause so much pain and so much heartache and so many hard feelings, and people are entitled to change their minds. But as far as I know, that is the agreement, was that the kids would be kept together and Larry and Kay would make sure that they had proper funerals and ceremonies. Hi, Beverly. Does Chad not having the same diagnosed mental health issue with which Lori has been diagnosed work against him in terms of the death penalty remaining on the table for him? I don't think so, because there's nothing that I heard from the judge that indicated that he was going to take that off the table because of her mental health issues. It came up in the defense's motion. I mean, they had several reasons why they said they wanted the death penalty taken off the table, and one of them was, he was a little flippant and obviously frustrated at that point and said, we don't execute witches anymore. And there was some conversation about, is she mentally ill or is she just evil? So I don't think it hurts him, because I don't think the judge made this determination based on her mental health. Idaho's a funny state for mental health defenses, and it's kind of an upward battle for mental health diagnosis in Idaho. So I don't think at any point Chad saying, "Hey, I have mental health issues and diagnosable issues," would work for him. I think, and I am not, please understand, I'm not a psychologist. I don't even play one on YouTube. But I've been around defense attorneys and criminal forensic psychologists a long time. So I think there is a vast difference between someone like Chad, who may have what psychologists call a personality disorder. He may have some sort of narcissism or some other sort of personality disorder. And I once had a psychologist tell me, like 70% of people have a diagnosable personality disorder. It is the human response to our life experience. And if we've had trauma in our lives and we've had upbringings that weren't ideal, then people can develop personality disorders. That doesn't mean they're not functional. It only means that they look at the world in a way that's slightly, according to the diagnostic manual, slightly skewed. That is vastly different than someone who is diagnosed with a delusional mental health condition. Now, as far as we know, and I expect this is going to come out at trial, the reason she was committed is because she was delusional. She has some form of schizophrenia that would cause delusions. So, yes, Chad could be personality disordered and still be very functional when it comes to understanding his rights and be very competent about in the legal sense. And that would be kind of at odds from what was going on with Lori when she was committed. So, yeah, I don't think it will help him at all in getting out of the death penalty. Because I think it's important, if you listen to the judge's ruling from this morning, he absolutely discounted the issue of her mental health, said it was not a factor in his decision. The only factor in his decision was the discovery violations. Good question, though. You guys are on it tonight. Wow, 298 in the chat. Let's get that over 500. Tell your friends. Text your friend. Tell them. Tune in. Lori's on live. Hi, Jam. Question: do you think the discovery issues will cause further issues that could affect the prosecution's ability to make a compelling case? The judge mentioned they may have to deal with other issues. Yeah, one of the things that they talked about was the fact that one of the remedies, one of the punishments for the prosecution not turning discovery over in time would be literally to say you can't bring in this evidence, that evidence, this evidence, and gut the prosecution's case. And the judge said he did not think that that was an equitable remedy because the prosecution has the right and the responsibility to represent the people in bringing this case. So we don't want to hamstring them either. So the judge felt he was doing what was the most equitable and the thing that ensured due process by taking the death penalty off the table. But there were some conversations about the fact that there was a specific motion in limine. Now, motion in limine is asking the judge to make a pretrial evidentiary ruling to limit some piece of evidence from coming in. Jim Archibald filed a motion in limine asking the court to keep out any of that late disclosed information. So the judge said he was going to issue a written order, which is important when you're days from trial to have it in writing. He was going to issue a written order giving them the limitations of that motion in limine. So there are other evidentiary decisions. Now, if you followed the Murdoch case, Judge Newman in the Murdoch case was very hesitant to make evidentiary rulings until the evidence was actually in court and out there. If you recall, they were asking for a motion in limine, and the judge said, I'm not going to do that. I'm not going to require that you either introduce or don't introduce certain evidence. I will make those rulings when they come up before me in court. So, but because of these discovery violations, I think Judge Boyce is being very clear about the boundaries of what the prosecution can bring in and what they can't. So I think he said he was going to try and get that out tomorrow. So we may have a better idea of what it is that he's going to limit in terms of the actual evidence. So good question. Hi, Carrie. Carrie says, I'm disgusted with the prosecution and Judge Boyce. They let the families and loved ones of the victims down, and even worse, the victims themselves. They should be ashamed of themselves. You know, I can't argue this. I think Judge Boyce was indecisive early on in the case. I think he's, as I say, I think he's gotten stronger, sort of found his feet, and I'm encouraged by that. And I can't disagree. The prosecution was absolutely not up to taking this case, and they insisted, for whatever reason, on keeping it. There were, thank you for whoever texted their friends and got us up to 504, by the way. Please hit that like button because it does affect the algorithm and how often we show up in feeds. I want to thank everybody. We're over 5,000 subscribers. We're actually almost to 6,000 subscribers, and we're just humming along. So thanks. Back to the question. I think that the prosecution, they were inexperienced. None of them had ever tried a death penalty case before. I'm not even sure any of them have tried a murder case before, but I know none of them have tried a death penalty case. I think they made a huge tactical error in not hiring someone to manage all this discovery, because discovery can be, in this kind of a case where they're talking about terabytes of information, it can be overwhelming, and it's a full-time job. So I think that they made some big mistakes in that regard. I do feel that, at least for Rob Wood, because he's been involved in this case since the very beginning, since they filed the initial charges and brought her back from Hawaii because she hadn't disclosed where the children were. So I understand that he has a relationship with Kay and Larry, and I understand that he feels a sense of responsibility. I remember him early in the case when the kids' bodies were found saying, I understand that these kids weren't here very long, but they're our kids. They were from our community. And I completely understand that sentiment. I completely understand how a lawyer can get wrapped up in a case and feel a tremendous sense of responsibility. But we do have an overarching responsibility to make sure that we're doing the kind of job that does justice. And it's hard to see how some of the things that they have done are doing justice. So I feel very much for Kay and Larry, and I will reach out to them. And I do understand it is a huge difficulty for a lot of people. I mean, we haven't talked about Colby recently, but he lost his sister and his little brother, and has essentially lost both his parents. So, I mean, it's a lot for a lot of people. I don't know whether, had she been convicted of the death penalty, that would have felt like closure for those people. I don't know them well enough to know whether that would have been their feeling. So I think we're steaming ahead with getting justice. She's going to be held to account, and I think beyond that, we need to sort of turn it loose and allow the healing to happen for the families. Nikki, what do you think Pryor thinks of this decision? I think he's probably happy for for Lori's defense team. I think he's probably second guessing himself a little bit about getting Chad's trial set out. But I think he's also sitting down and wondering, okay, what can I do now? Now that this ruling has come down, what are the chances that I'm going to be able to get the death penalty taken off the table for Chad? I mean, that's where I would be going if it were my case, is I would be sitting down and saying, okay, now that I have this reality, what can I do to make that happen for Chad? And does this help me get there? So, I mean, he's probably got mixed emotions. I would have, but life is about mixed emotions, about wondering what ifs. What if I'd done something else? Sabrina Holmes. Many people believe Chad will testify against her, but if he does, couldn't that testimony be used against him at trial? Absolutely. Chad will not testify against her, not without a plea deal. What happened with the severing of the trials was, now that Lori's trial is going to go first, there are a lot of benefits, but there are a lot of downsides too. One of the benefits of the case is that John Pryor and Chad get a look at the prosecution's full case. And that's a huge upside for them. On the downside, they also are going to have to take into account all of that discovery that is going to be excluded out of Lori's case. So different evidence is going to come in at Chad's trial than at Lori's. Some. But in this case, Lori cannot compel Chad to come in and testify against Lori, because he can invoke his Fifth Amendment rights. Now, the flip side isn't true, because if Lori is already tried and adjudicated, she's been tried, convicted, and sentenced, or she's been found not guilty, she no longer has a Fifth Amendment right, and they can call her to come and testify against Chad. So that's another sort of downside for Chad in having these cases separated and Lori going first. Catlink. Question: if children were released before Lori was convicted, would she legally have the say about their funeral arrangements as their mother? Potentially, although I think at this point, the court would likely overrule that. I think the court would just say, no, you don't get to decide. I think that the Cox family probably has had some input. I'm sure they would like them both to be have LDS funerals. They would like them to have funerals that comport with LDS doctrine, and those are probably reasonable requests. But I think they have come to the agreement that the kids need to be together. I'm sorry, I talked over. My mod thought I was done and put the next question up. Nate Eaton said the parents of Tammy asked for a way to watch the trial, elderly and frail, and they were refused. Yeah, this is a problem, and I'm really upset about this. Here's the thing. The judge has said no cameras in the courtroom and no video that will be stored, will be saved. So what the judge has ordered at this point is a closed circuit connection that will live stream in real time the proceedings to both an overflow courtroom in Ada County and to Madison County, so that people in Fremont and Madison can watch. So the judge has declined to do anything that is where that video gets out of someone's control. And it's a problem. I said from the beginning, this is a problem, because how do you keep someone from intercepting that signal, or from filming it from one of the overflow sites? I mean, I think it's easier to control the overflow sites, but I think the judge's concern is if you allow someone to appear and get that video feed, there's nothing to guarantee that they're not recording it, that they are not preserving it. And the judge has been very clear that the video portions are not to be preserved. I disagree completely with this. I've disagreed from the beginning, but the judge has said, I'm not allowing any other access. I don't know why, and I think it's cruel. But at this point, they are stuck with listening to the same audio that everybody else is going to listen to. And it's very unfortunate. I had noticed in the trial record, there were a couple of requests. One was for a witness to appear remotely, and that was denied. And the other was a request to access remotely. And I knew that the person who requested, their last name is Douglas, so I assumed it was somebody within Tammy's family. Yeah, it's unfair. Trisha the trucker, you still didn't say where you are, girlfriend. Why can't they Zoom the trial to family with a special link? Well, that's the question. I think Judge Boyce is really hung up on making sure that never gets stored anywhere, recorded anywhere, so it can't later turn up. I think he's really hung up on that. And if you allow people with a special link to Zoom into the conference, there's no way to keep them from recording it. And I think that's where his hang up is. Marshall Dove. What is the biggest question that you want answered, a big detail or not, you most anticipate coming out at the trial? Is there a piece of evidence we should look for as a huge deal if presented? Well, I think one of the things that's been perplexing, and I don't even know if the state knows this, but we don't know where the children were killed. We don't know where Tylee's body was put into the condition it was. We don't know where the actual crimes occurred. So that's kind of interesting. And I'm also quite interested to know what it is that Zulema Pastenis has to offer that earned her some immunity. So those are two questions I'm very interested in. But I think as the trial unfolds, there are going to be many gee whiz moments because I'm convinced that we don't know the whole story. Hi, Bama girl. Can an appeal be taken to a higher court about the judge's decision to deny Tammy Daybell's parents' request to watch? Unfortunately, no. The Idaho law that gives the trial judge the authority to make that decision specifically says this is not an appealable decision. You can't go get an interlocutory order before the trial starts. You can't appeal the judge's ruling. It is final. So the only way that changes is if Judge Boyce somehow changes his mind. And I agree. It's very sad. Hi, Laura. Death penalty's off the table now. Wasn't that his big issue? Death is different, can no longer be his go-to response for why he isn't agreeing to cameras. Well, I think that's true, except that the death penalty is still on the table for Chad Daybell. And that means that they're still going to be fighting about getting an unbiased jury, and they're still going to be fighting about not allowing cameras in the courtroom pre-trial. And now that he's set this precedent, I would not expect him to allow cameras in Daybell's trial either. I do want to point out that depending upon how the trial unfolds, either for the prosecution or the defense, there may be many reasons that become very apparent for them to continue to do plea negotiations. If you recall, Lori and Chad were both set for preliminary hearings in the previous felony cases having to do with the destruction of evidence. Now, they didn't have preliminary hearings because the murder charges went to the grand jury. That's why it took so long to bring them, because COVID hit and they couldn't convene the grand jury. But the murder charges went before a grand jury, so they didn't have to have a preliminary hearing. But the earlier charges, they held a preliminary hearing. And Chad's preliminary hearing went forward once Lori had seen the evidence that occurred in Chad's preliminary hearing. She waived her right to the preliminary hearing and stipulated to the indictment. So, I mean, that's a smaller scale sort of situation, but I could see a situation where things that come out at the trial maybe don't come out the way that John Pryor wanted them to, or they come out in a way that's more inculpatory for him, and he may cut a deal. So that's yet to be seen. I wouldn't bet the farm that Chad's gonna have a trial in October or in the fall or next year. John Pryor is asking that it be set next year. I think it's more likely that it'll be sometime late this year, but we'll have to see. No new trial date has been set yet. I'm sure that they are talking to Ada County, trying to get that figured out. It's possible that Ada County wants to wait until they see how Lori's trial goes. Don't know, but I could see them doing that. So how are the families planning to manage these ridiculous restrictions? Are they listening live? There is no live broadcast, audio broadcast either. They will have to do the same thing as everybody else. They will have to listen to it when it's released after court adjourns. So it is, I'm sure it is a really big hardship. Not only because there are elderly people both in Utah and in Louisiana who are not able to travel, but there are young people who have jobs and families and who can't leave for what could still be 6 to 8 week trial to make sure they're there. So I think it's a problem, and I don't think the judge is going to address it. I think he's just saying you're going to have to deal with it because it is what it is. Kim Chapman. Hi, Kim. If they allow the audio to be distributed after every day, what exactly is that protecting, as it's not streaming the audio real time? I wonder who would be protected by not releasing the audio until after court. Well, for one thing, and I don't mean to be flip, but for one thing, if you've been a trial watcher for any period of time, you have seen that often there are things that are taken up outside the presence of the jury, and there are things that are taken up at sidebars with a judge, and those are things that are typically not in the recordings. So not streaming it live, only allowing the audio to be released at the close of day, make sure from the court's perspective that none of that stuff was picked up on audio that shouldn't have been, and they can make sure that the audio is clean, I guess, for lack of a better term. I mean, I think that that's what they'll say their rationale is. But we saw it very effectively in the Murdaugh trial. They were able to turn off mics when the defendant was conferring with his counsel, turn off the mic when the judge was holding a sidebar. And we clearly saw a lot of stuff that happened outside the presence of the jury. So I think it's a little bit of a weak argument, but I think he's sticking to his guns. And I think the fact that the statute says it's his decision alone to make means that he is empowered to do that. And I think he has decided that that's the hill he's going to die on, right? I mean, he's just decided that cameras in the courtroom are where he's going to draw the line. Marshall Dove. For Chad to get the death penalty, wouldn't they have to prove he was physically part of the murders of JJ or Tylee? I did not think it was known yet who actually murdered them versus conspiracy. No, because in Idaho, and this is different in Arizona, by the way, in Idaho, the same conspiracy to commit murder is the same sentence as murder. And because they met the aggravating factors for the death penalty, the conspiracy to commit murder carries the same sentence, potential sentence. So he could and likely would get the death penalty if he is convicted, even if it's just on a conspiracy theory. Even if he were found not guilty of Tammy's murder and only guilty of conspiracy to commit the murder, he could still get the death penalty. Yes, please. Please like, subscribe, hit the bell for notifications. We are at 573 people watching tonight. Thank you so much for joining us. I always say, I know that you have plenty of things that you could spend your time on, and I appreciate it when you spend your time with us. I'm going to try and get a newsletter out tomorrow. We'll see. Depends on how ready I am to take off on Thursday morning. but I'm going to try and do that. But we have other cases to talk about tomorrow night as well. So we'll try and get a newsletter out tomorrow, try and get those quilting videos out so we can wrap up our quilt project. I just want to say thanks again to everybody who donates to our moderators. It really makes them feel great. It makes them feel appreciated to know that that y'all recognize that they do all the hard work. I get to sit here and just run my mouth, but they're the ones who are watching the screen and doing all the hard work. I just have one other thing I want to share with you all. And that is that I very consistently get feedback back through our comments section, which, by the way, you can always leave if we didn't get to your question, please drop it below. I consistently get comments from people who say, you have the greatest followers. You have the nicest people in your chats. I've never been to another true crime YouTube channel where people are so polite and so respectful and such generally nice people. And I want to say, I agree. We have the best followers ever. So I'll see you tomorrow night. I will get links out as soon as I have them to the Surviving the Survivor on Monday. And if I don't get to see you tomorrow night, have a great weekend, and we'll get back together next week. Take care, everybody, and good night.